My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I am here to provide public notice. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution of the United States is the overarching requirement that every state must follow. I don't think anyone here would disagree with that. States cannot enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws are more powerful than the Constitution, and that is simply illegal. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. However, the state of Ohio has enacted its alternative legislation that permits prosecuting attorneys, police officers, and judges to charge by way of information as opposed to indictment, and that is simply illegal. An emolument violation is when you pay a public official to commit a crime. There are two areas of the Constitution that reinforces this. The first is Article 1, Section 10, and that's where it says that no state shall create any law that shall impair the obligation of contract. I'm sorry, go ahead. Reclaim time.
I'll take your time or anything, but the signers seem to have a little bit of trouble. I don't know. I know you talk pretty fast. I do too. If you can maybe just slow
The
down
interpreters.
just a little. Yeah. The interpreters.
We're only given 2 minutes, but so can I?
Please continue.
Please
Do
continue.
you want me to slow down? And
Just a little, and we'll give you a little more time.
okay, thank you. So an emolument violation is when you pay a public official. The emolument is spelled E-M-O-L-U-M-E-N-T. Emolument. An emolument violation is when you pay a public official to commit a crime. So there were two areas of the Constitution that reinforces this. The first is Article 1, Section 10. That's where it says that no state shall create any law that shall impair the obligation of contracts. Your police officers, your sheriff, your judges, your prosecutors, they're all under a contract. That is a contract to perform based on their oath or affirmation that they took to support and defend the Constitution of the United States. The second area is the 14th Amendment, and that's where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated within the Bill of Rights and the first 10 amendments. The state of Ohio, unfortunately, has enacted in its inferior constitution a law that is permitting your public officials and your law enforcement officers, whom you all pay, to violate the supreme law of this land. Mr. Tanawah Downing is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 people currently incarcerated across America, but there's a lot also here in this state. I'm here to notify you that you cannot continue to pay public officials to break the law of the Constitution. Criminal sanctions, unfortunately, can come from that. So I'm asking you, honorable individuals, please take a look at what I said. Clause 1 of Amendment 5 to the United States Constitution. Confirm what I'm saying to be true, and then go out and direct your public officials to act in a lawful, constitutional manner that is consistent with the obligations codified in the Constitution of the United States. I do have a notice I would like to put on the record, and I appreciate you guys extending my time. Thank you.
Please give that to the clerk, and we'll make sure we all get it. Tanawah Downing is our second speaker. You've got the pleasure of the floor for 2 minutes.
Thank you so much. I do speak fast because there is a lot of information that's going to have to get put out right here, and I thank you guys so much for letting us speak. So I'm the civil rights litigator from Washington, D.C. that Ms. Saxon was just talking about. I'm here because I need to provide a little bit of clarification so we can understand what was just said and how do we move forward. I have approximately 12,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment as required by the Constitution from right here in the state of Ohio. Many are from within the city of Cincinnati. These affidavits, they identify two different crimes in particular. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. The second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that says is that when two or more persons conspire with the purpose of depriving any person of any rights secured by the Constitution commits that crime. Now, the laws of criminal conspiracy with regard to public officials, what they say is that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of a commission of the same, neglects or refuses to do so, may be joined as offense the action. So upon having been provided with this notice, letting you know that you guys are paying for the sheriff's department to go out and execute a warrant that is unconstitutional because it derives from a prosecutor who used the incorrect charging instrument in violation of the Constitution of the United States, I would ask you guys, please, let's go ahead and get this addressed. Let's work together to do that. Okay. Now I know you're going to go to your attorney and you're going to ask your attorney as soon as we're done whether or not what I'm saying is true. That attorney is going to point you to a case from the United States Supreme Court in 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That must be done by an authentic act of people in accordance with the special amending procedure of Article 5. So I know it's a tough decision. You guys are going to have to decide whether you're going to follow a judge-made ruling or the Supreme Court or the Supreme Law of the Land, the Constitution of the United States. I trust and pray that you guys make the right decision because if we don't, it could be detrimental. Thank you guys so much. God bless.
Thank you very much for coming in.